Hello, and welcome to the Blogging Pod. On July 11th, 2025, a federal judge in California issued a ruling that was hailed as a significant win for civil rights, temporarily halting ICE and DHS operations in several Southern California counties, including Los Angeles, that rely on racial profiling or lack of probable cause. The ruling came from a judge on the U.S. District Court for the Central District of California, who stated there was a mountain of evidence showing immigration agents had been targeting brown skinned individuals, many of them U.S. citizens or legal residents, based on appearance, language, or location rather than any legal justification. The court also ordered that anyone detained inside the federal building in downtown Los Angeles must be given access to legal counsel daily. On the surface, this ruling appears monumental, but as with most things involving ICE, what's written in legal filings doesn't always translate to action in the streets. This brings us to a critical point: enforcement. Local agencies like the LAPD and the LA County Sheriff's Office have long distanced themselves from official ICE collaboration. In public statements, both agencies claim they no longer honor ICE detainers and that they avoid any involvement in federal immigration enforcement. But on the ground, it's a different story. These agencies may not be directly working with ICE, but they also are not actively stepping in when federal agents snatch people off the streets without a warrant. In fact, many cases they simply stand by saying it's not their jurisdiction and let it happen. So the question becomes, if local authorities aren't stepping in, who will? ICE has a long and troubling history of operating with unchecked power. Agents frequently fail to identify themselves, wear masks and body armor, and use unmarked vehicles to detain individuals at bus stops, street corners, or in front of schools. Worse still, they often refuse to answer questions or even confirm whether someone has been taken into custody. Legal advocates have documented dozens of cases where U.S. citizens, some even veterans, have been wrongfully detained for days, even weeks, without access to counsel. One such case currently that happened just raising alarm involves a U.S. veteran reportedly taken during a farm raid. He was allegedly injured in service, yet authorities still have not disclosed his location, and his family can't confirm if he's in federal custody at all. These are not isolated mistakes, they're synthetic failures. And this is where we come full circle. If ICE can ignore court rulings, detain U.S. citizens, invade oversight, and face no legal consequences, what exactly does a federal restraining order achieve without real-world enforcement? To hold ICE accountable, it's not enough to issue court orders. There must be mechanisms in place, federal, state, and local, that force compliance. There must be transparency when detentions happen, and there must be a legal pathway for families and advocates to find their loved ones and demand answers. And without that, this ruling may offer symbolic relief, but little meaningful change for the people most at risk. Today's podcast sources are from ACLU of Southern California press release, NPR's July 11th coverage of the ICE ruling, the Los Angeles Times report on the federal judge's decision. Thank you for listening. Until next time, bye-bye for now.